Losing a loved one is undeniably one of life's most difficult experiences. But what often compounds that grief is the unexpected and stressful process of navigating the probate court system. While many of us focus on writing a will, there is a hidden, often overlooked tool that holds incredible power in your estate plan. They are called beneficiary designations. When set up correctly on your retirement accounts and life insurance policies, beneficiary designations act like a legal fast pass. They allow your assets to flow directly to your chosen loved ones, entirely bypassing probate court.
You might think your last will and testament is the ultimate authority on who gets what when you are gone. But here's the hard truth. Beneficiary designations generally supersede any instructions in your will. Because they are legally binding direct contracts, they bypass the probate process entirely.
Imagine updating your will to leave everything to your children after a divorce, but forgetting to update your life insurance policy. When you pass away, the insurance company will pay out directly to the named beneficiary on file, even if it is your ex-spouse. Your will simply does not change this outcome. This strict legal rule applies to many of your most valuable assets. It covers retirement plans like 401ks and IRAs, life insurance policies, standard bank accounts with payable on death designations, and even transfer on death brokerage accounts. If you do not align these forms with your estate plan, your true final wishes might be completely overwritten. Let's start with a shockingly common blunder, leaving the beneficiary form completely blank. When you fail to name a beneficiary, your hard-earned assets don't just magically go to your closest relatives. Instead, they are forced into probate, a lengthy, public, and incredibly expensive legal process. Mistake number 2 is the dangerous set-it-and-forget-it trap. Imagine passing away, only for your entire life insurance payout or retirement savings to be handed directly to your ex-spouse, simply because you forgot to update your paperwork. Sadly, the courts will strictly enforce that outdated document. To protect your estate plan, there are a few simple solutions. First, always name both primary and contingent beneficiaries, creating a solid backup plan. Second, treat your forms as living documents. Review them every 3 to 5 years and immediately after major life events like marriages, divorces, or births. Mistake number 3 is naming a minor directly as a beneficiary. While you want to provide for your kids, minors cannot legally own or manage significant assets. Direct naming forces the court to step in and appoint a guardian. This process is expensive, time-consuming, and delays their access to funds. Instead, use practical solutions. You can set up a trust, open a Uniform Transfers to Minors Act account, or officially designate a guardian of the estate. These options protect the assets and bypass unnecessary court battles. Mistake number 4 is vaguely naming a trust. A trust is a powerful tool, but it requires absolute precision. Scribbling a generic name on a form can invalidate the designation entirely. You must use the exact, full legal name of the trust, along with its specific creation date. Always review these documents closely so your assets do not end up in probate court. Let's move on to mistake number 5, ignoring the taxman. Not all inheritances are treated equally. If you leave a traditional retirement account to a loved one, they generally pay income tax on those distributions. Plus, under the Secure Act, most non-spouse beneficiaries must empty the account within 10 years, potentially triggering a massive tax bill. On the other hand, life insurance proceeds typically pass to beneficiaries income tax-free. Always consider the tax burden you are leaving behind. Mistake number 6 is forgetting community property laws. If you live in Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, or Wisconsin, your spouse has a legal right to half the assets acquired during marriage. Want to name someone else as your primary beneficiary? In these states, you absolutely need your spouse's written, notarized consent. Without that legal sign-off, your carefully chosen beneficiary designation could be completely invalidated. Mistake number 7 is treating your beneficiary designations as isolated decisions rather than pieces of a comprehensive estate plan. If your will says one thing, but your retirement account designates someone else, the beneficiary designation almost always wins. This lack of coordination can easily derail your final wishes.
The solution is integration. Work closely with an estate planning attorney to ensure every asset, policy, and account aligns perfectly with your primary estate documents, like your will or living trust. Mistake number 8 is leaving assets directly to a loved one with special needs. Inheriting even a modest sum can instantly disqualify them from vital government assistance programs like supplemental security income or Medicaid, putting their long-term care in jeopardy. To protect their eligibility, never name them directly. Instead, establish a special needs trust and name the trust as the beneficiary. This legal safeguard allows your loved one to benefit from your assets without losing their essential government support. Let's talk about mistake number 9, using vague language. It is incredibly common to see someone simply write "my children" on a beneficiary line. But what if you have stepchildren? What if one of your children passes away before you do? Ambiguous phrasing is a fast track to probate court and bitter family disputes.
The solution is simple but crucial. Always use precise identifying details. List their full legal names, dates of birth, and exact relationships to you. Leave absolutely no room for interpretation.
Finally, mistake number 10, ignoring state laws. Estate planning is not a one-size-fits-all process across the country. Laws governing community property, spousal rights, and probate vary significantly from state to state. What works perfectly in New York might be completely invalid in California. Because these legal nuances are so location-dependent, seeking professional legal advice in your specific state is absolutely essential to ensure your estate plan functions exactly as you intend. Let's run through a protection checklist to secure your estate plan. First, inventory your assets. Make a comprehensive list of all your accounts and policies. Second, review your designations. Obtain current copies and double-check them. Third, coordinate with your estate plan to ensure these designations align perfectly with your will or trust. Fourth, seek professional advice. An estate planning attorney can provide invaluable guidance. Fifth, update regularly. Revisit your designations after any major life event. And sixth, keep meticulous records. Store copies of all your beneficiary forms in a safe, accessible place. Finally, please note that this video provides informational content only and does not constitute legal advice. Always consult with a qualified professional for personalized guidance on your estate planning. Thank you so much for watching. As we've seen today, properly managing your beneficiary designations is a critical step in protecting your legacy. A simple mistake can have devastating consequences, but with a little care, you can secure the future for your loved ones. If you found this video helpful, please give it a thumbs up, subscribe to our channel, and leave a comment below with any questions. We'd love to hear from you. To make sure your estate plan is fully protected, visit funeralist.com for more valuable resources and guidance. Don't leave your legacy to chance. Check out our other videos on estate planning, and we'll see you in the next one. Take care.